Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Before we jump into today's topic, as always, if you'd like to discuss estate planning or probate, contact me at njestateattorney.com. So today's topic is about handling your medical decision making at this point. And let's just preface this really quick. Prior to March 2020, we all knew estate planning and creating a medical power of attorney and a living will were important, but we never thought we'd see the day where a disease or something would spread rampant and even harm those people that were physically fit and incapacitate them to the point where they couldn't make a decision. We always associated estate planning with older people, but times have changed. It's 2021 now. We're over a year into this pandemic, and there's no time like the present to create your living will and your medical power of attorney. So, what does a living will do? The living will, you are making the decisions in your current state of how you want your care to be handled. Do you want life-saving treatments? Do you want a do not resuscitate? Do you want a feeding tube? Do you want to live like a vegetable? Do you want to remain in a coma until maybe treatment is found for you for what you have? Or do you want to just be taken off of any and all life support and pass peacefully? So that's really what a living will is you're making the decisions. Then you go into, on the flip side, you have a medical power of attorney. Now, what does this document do is you're appointing an individual or a healthcare representative to make a decision for you when you're incapacitated and can't make a decision. So that could be you're in a medically induced coma, you're in a coma, stuff like that. A life-saving surgery for you because you were in a car accident and they need to know now, doctors need to know, do you want this, does the healthcare representative want this done? And is this in the wishes of you? The other thing, though, is, and what's interesting is, you can actually, in your medical power of attorney, tell your healthcare representative that, look, you have to abide by my living will and there's no deviation from it. And that's something that some people love because, look, basically they've told their healthcare representative what to do, and basically it's up to the healthcare representative to, in other words, just pull the trigger and order the doctors to say, look, this is what the living will says, this is what the person wants, I have to do this. On the flip side, you can also you can leave your living will, but you could also say, look, this is more of a guide for the healthcare representative, and I'm going to leave this to the healthcare representative to make the best decision for me because I trust their judgment. But here's an idea of what I would like if I were alive and could say something. And then it's up to the healthcare representative to either abide by the living will or do what they feel is in the best interest of the person. Now, the big question I get from a lot of clients is, you know what, David, what happens to me if I'm in the process of drafting these documents and something happens to me and I haven't signed them yet? Well, that's a great question. So what happens is, at least here in the state of New Jersey, there are healthcare representative laws and statutes. And what these basically do is it allows the hospital to go to the next of kin, and they become the person, the go-between between the doctors, and they can basically appoint the healthcare rep. They're not appointing the healthcare representative, but they're asking the next of kin. And if there's multiple, so let's say you have 4 children, all 4 of you have an equal say under the statute. And let's say it's 2-4 pulling the plug on taking you off of life support and 2 against it because they're holding out hope. Well, now you're at a deadlock and the doctors can't do anything. So what happens is now you have to go to the court and get court intervention, which is money and time, and it's already in a difficult emotional state. And we know the courts don't move quickly enough. So now you're going for a guardianship, and now it's your 4 children duking it out in court to basically say to the judge and have a judge say, you are the best of these 4 people, go make healthcare decisions. You are now the legal guardian of your parent. So we want to avoid that court intervention. We want to avoid that cost, that time, and these deadlocks. That's why we create living wills and medical powers of attorney, so we can avoid these deadlocks in the court, so decisions can be made immediately. So we're not sitting there waiting, and you aren't in a state that you don't want to be in. It's also important to speak to the person that you're going when you nominate your medical power of attorney, to speak to them. If you're married, it's usually your spouse. If you have children, sometimes you want the child to decide. It all depends. It's something that you need to sit down and personally ask yourself, who can make the decision best for me? Actually best for you. So with that being said, living wills, medical powers of attorney, there is no time like the present today, especially over we're 13, 14 months into a pandemic, into the COVID-19 pandemic. Hopefully it starts dying down, but there is no better time than today to start this process. As always, my name's David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. If you have any questions pertaining to estate planning or probate or about this video, please contact me at njestateattorney.com. I'd love to sit down with you, set up a time, free strategy session to discuss anything further. Have a good one.